and welcome. Very interesting topic today. Impeachment. Today we're going to have a legal education on a very technical matter. A case that will further put the judicial system of Ghana, to the test. We'll try it if it goes through the full walk. Impeaching the EC, it's not as simple as it sounds, and it's not as straightforward. Now, go things back to July this year, where some 17 faceless individuals sent a petition to the presidency asking for the EC to be impeached, which the presidency forwards to the Chief Justice, who will then look through to ascertain whether the petition or the charges brought against the EC have any merit to proceed to a trial or the matter looking into further. Well, today the Chief Justice is saying that, yep, he's looked through the petition and thinks that, there is a case for the EC to come and answer. But the case is, while the case is going on, or the issue is while the case is going on, should the EC still stay in office? Because, the deputy EC has been asked to go on suspension because there's a similar case that brought against her, and while it's being looked into, she's been asked to set aside. Does that same rule apply to the EC, or is it different? And what's the brouhaha about? Because if you listen to political commentary, there are so many people who are agitated on the president himself as to, look, Mr. President, you can't do that. How much influence has the president got in this case? We are yet to find out. My name is Nana Ansakwao IV, Chief of the Little Republic of Akomo Dumasa, your favorite host, and today we're all going to get educated. I have no clue what these legal matters is, but we'll find out in the next hour. Don't move. Well, thank you very much for staying, and today we're very, very fortunate. I have two people in studio who I think by nature they're teachers, and then they added law to their profession. But by their calling, I think they were called to become teachers. But along the line, they found their foot in the legal profession. So when they add the two, they're very good. Sitting right next to me is Kojoga Adawudu, no stranger to the show at all, private legal practitioner. You're welcome.
It's a pleasure.
And Afishapa. It's been that long. And Samson Ladi Ayenini, he probably has to introduce me. He doesn't need any introduction. Host of Newsfile, private legal practitioner, and a family member of this house, and a very, very good dear friend, Samson Ladi Ayenini. Samson, you're welcome.
Thank you. I'm here. I've obeyed your summons.
Sometimes it works, though. This chiefly thing. Sometimes I have to apply put the media aside and apply the traditional thing, and it works.
You can't refuse that.
But politely, though. I do it very politely. I do it very politely. Samson, let me start with you, because the whole thing is a bit confusing. The people who are angry with the president for trying to sack the EC, boss. The other people are saying, well, the president had no matter in it. He only had to forward the petition. Can you educate us? If I find something wrong with the EC, why don't I, send the EC to court or send him somewhere? Where does the president come in the matter?
Right. The Constitution of Ghana provides that justices of the Superior Court, and by justices of the Superior Court we mean judges who sit in the High Court, in the Court of Appeal, in the Supreme Court, that when they have been found to have misconducted themselves in the course of their work, there is a way to deal with them, and the way to deal with them is through this kind of process called impeachment, so to speak. And that they needed to be given that sort of space so that those who are responsible for appointing them cannot get up one morning and say, something has happened, I dislike you, get out. So their term of office has been secured. They have security of tenure.
Okay.
Once you appoint them, you can't remove them.
Until they're 70.
Yes, and until they have become incapacitated by way of ill health, or that they have acted in ways that the Constitution calls stated misbehavior. That's what is provided for in Article 146. Now, if they have misconducted themselves and you want to remove them from the office, it doesn't take the say-so of the president or anybody. So there ought to be a process. That is the process we have going on now. Because we also felt that the persons that are appointed into the independent constitutional bodies as chairpersons and deputies also deserve such protection of tenure of office and independence, particularly independence of their office. You don't want anybody to just remove them anytime at their whim. So they too, when they are appointed, are giving the terms and conditions of a justice of the Court of Appeal if they are the head. If they are the deputy, they are giving the terms and conditions of service of a justice of the High Court. Meaning, if you want to remove them, you could only remove them because of ill health or because of stated misbehavior. And by that, you will need to do a petition. The Constitution says in Article 164, Clause 3. 146, 3. It says that when you present that petition to the president, it says, if the president receives a petition for the removal of such persons, the president shall refer it to the Chief Justice, who shall determine whether there is a prima facie case. So, in the architecture of the Constitution in Article 146(3), the president is what I have described as a mere conveyor belt, or call him the post office, through which the petition is put forward for the purposes of the impeachment process. Now, so very simple. When I was leading Richard Nyama for the removal of the Shraj boards from office, we took the petition to the presidency on the 30th of September, 2014. Within a month, the petition had been forwarded to the Chief Justice. And the Constitution says it is the Chief Justice who shall determine whether there is a prima facie case. So the Chief Justice went through the whole thing. In fact, we understood that there had been several others who had also presented petitions seeking the removal of the Shraj boss from office. But the Chief Justice looked at all of them and came to the conclusion that it was Richard Nyama's petition that was a proper petition and that had substance, and therefore made what you call a prima facie determination. Prima facie determination simply means that you have a case to answer, so come and submit yourself to the process. Prima facie determination means on the face of the petition that has been submitted to us, on the face of the document, we find something credible to warrant an investigation. So when the CJA does the prima facie determination, the Constitution now proceeds further to say, when a prima facie determination is made, a committee of 5 shall be set up. 3 of them shall be justices of the Superior Court. In Richard Nyama's case, 2 of them were justices of the Supreme Court, and 1 was a justice of the Court of Appeal. In the present case, regarding the Charlotte Osei and the others, we are learning that 1 who is chairing is a justice of the Supreme Court. In fact,
he was also in the Richard Nyama matter as well, but he was not the chair. Justice Eniyebwa was the chair. And now there are 2 justices of the Court of Appeal. And then the Constitution says these are supposed to be appointed not by the Chief Justice. They will be selected by the Judicial Council. The Judicial Council is a different body completely set up by the Constitution with different representation from various sectors of the Ghanaian society, including chiefs, and 4 persons appointed by the president. The Ghana Bar Association is represented, and several other entities are represented. They appoint the 3 persons who must be justices of the Superior Court. And then there are 2 others who are appointed by the Chief Justice on the advice of the Council of State. When that appointment is made of the 5-member panel, then they will do what the Constitution says, inquisition into the petition. And then you go through the motions, and when everything is done, a verdict is pronounced.
On that note, I'm taking a quick break and I am coming back. I told you by the time we finish, we'll have law 101 degrees under our belt. Don't go. While we are understanding what it takes to impeach the EC commissioner, it's not as easy as that. Let me come to Victor. I know Victor was, had some objection of air. We'll bring it on air soon. But before, Victor, what's the wisdom of bringing the president in? Does it not just politically tag him? Can't you just go and give it to the Chief Justice if you have an issue? What's this post-buster business? What's the wisdom behind it?
I believe that the reason why the framers of the Constitution thinks that it should go to the president, that the president should be the person who should receive the petition, will be that mostly he appoints the people go through the process, and the instrument of the appointment is made by the president. Also, if you look at it with the confidentiality, and I believe that the oath of secrecy that is sworn, it is given to the president, and assume that when the president gets it, it will not get to the public. So I believe the confidentiality and the secrecy by which the petition should hold, it's the reasons why they believe that the president should be a person of integrity, credibility, that when it gets to him, it will go to the Chief Justice. So it will be only the president who will have knowledge of what that petition contains. Because at the end of the day, it is the same president who will act on the recommendation, whether to suspend or for the person to be impeached or not.
So the president has the final say?
Yeah, that's what I see. No, the recommendation that they make is what the president will implement.
Assuming they say, oh yeah, everything they've written is true, we've gone through it, and there's evidence is true, and so they write to the president, look, Mr. President, the petition they brought, we've read through, maybe out of the 27, 13 are true. Can the president say, well, it's okay, if it's only 13, let's just leave him there, or leave her there?
No, when that recommendation is made, just like what we are hearing from the grapevine or what's happening in this Charlotte Osei case, when the whole thing was summarized by the Chief Justice, I think the allegation was about 27 or 25 points. But actually what is being looked at now is less than those that has been raised.
Only 6.
Yeah, only six is being now looked at. Those recommendations, when they make it, it goes to the president. And the president will now implement those recommendations that has been made. Now, one of the things that makes it a little difficult is that the status of that committee is not clear. When you go to the case of the Ajay Chun, they see that although it might be a quasi-judicial committee, that is where you apply all the rudiments of the law with it, in that particular case, they see it as an incident of an administrative body, that the committee is set up is more like an administrative body, they go through the process. When the president decides that the rights and the liabilities that comes with the recommendation, then that would also mean that if it's an administrative body, the High Court can now have the power to review what has been done. You know,
if there's a Supreme Court judge in this commission, how does the High Court look into it?
That's one. No, if there's a Supreme Court, it's a body. Until the court itself clears it. It is in one case that they says that it's an incident, it's an administrative body. It could be administrative or judicial. But when they go through the procedure, the process, and you who is affected believes that the right thing has not been done, administrative bodies, if they finish all that they have done to make sure that it conforms with the law, all the rudiments of the law, natural justice, fair practice, you know, you've given a person a fair hearing, all this, the High Court has been given that power to review what has been done.
Hold on. I mean, this is layman question.
Yeah.
But if there's a committee and there are people in the committee from appeal and Supreme Court, which means it's like you and something coming up with a decision, and I'm coming to review it.
That's why the Supreme Court would have opportunity. I believe they will have the opportunity one day to determine the status of that committee that the Constitution has laid down. So what is the status? Is it a High Court or is it an extension of the Supreme Court? You need to look at it. It has not really been determined to know. But if you look at based on...
In 1999,
yeah,
the deputy NCCE chairperson,
Opon,
Dr. Jacob Emmanuel Opon,
yeah,
went through the same process. It was Justice Akwa who was the chairman of the committee, and Justice Akwa was a Supreme Court judge. Now, when they finished, and he was aggrieved, he was not happy. They didn't go to any place but the Supreme Court. So I think that ought to be clear, that if they finish the process and you are not happy about it, your only avenue to ventilate what you intend to do will be to go to the Supreme Court. So in that regard, I find that it is not a mere administrative process they are going through. In fact, the language of the Constitution, in Article 1464 thereabouts, is very clear that they are supposed to inquire, which is inquisition. And the nature of the panel, Superior Court judges, 3 of them, gives me the clear impression. And also with the precedent of the 1999 case, it's very clear that when you are dissatisfied, you go to the Supreme Court. So I think they do more than a mere administrative body's work. Now, you asked earlier, why bring the president in the picture? And you know our country is polarized politically. And so people are saying MPP, blah, blah, blah. I mean, there's a lot of this thing that goes on in this country. The president is the one who appoints these people by the power vested in him in the Constitution. Even though for each of them, if you are appointing a judge, he would have done that on the advice of the Judicial Council. Council of State is involved in the of course, Parliament is involved, Council of State is involved in the appointment of judges at a certain level. When it comes to appointing chairpersons of the independent constitutional bodies, EC boards, NCCE boards, SHRAD boards, these are independent constitutional bodies. He does it in consultation with the Council of State. So, because it is something that he does, it is only fair. Perhaps, maybe we should go back to our tradition and go back to the chief's palace. It is only fair that you don't do the processes without him knowing. So it's good judgment. It's good sense that you appointed somebody. There's a process to remove the person. We want you to be in the know that this is what is going on. So that's all there is about it. And you see, again, as he was intimating earlier, when he has done that job, Article 146(10) says that when a prima facie has been made and the process is to go on, the president has power to suspend the person pending the determination of the case. But the power to suspend, again, is a power that is exercised on the advice given by the Judicial Council. So as we sit, if the Judicial Council determines that we think these chairpersons, you know, Charlotte Osei, Georgina Mankwa, and Amadou Sule should be suspended whilst the process is going on, the president cannot just get up and say, I feel they should be suspended. No. It is the Judicial Council that must advise him that he ought to do so. When we were doing the Shrad case, we didn't wait. Immediately prima facie determination was made, we wrote to the president and said, look, we need to call people from Shraj to come and testify. If she's still there, she will hinder it, or they will feel reluctant to come forward. There are documents we are going to use. If she's still there, she might compromise the documents. Therefore, we say activate your power in Article 146(10) and suspend her while the process is going on. I'm sure he forwarded it to the Judicial Council. They looked into it and they said, yes, we think you should suspend her. And then he went ahead to suspend. Yeah. So you see, he performs functions from each stage of the process. The law says he suspends, and at any time, even before the process is over, he can revoke the suspension. He can say, look, I don't think the person should continue to be on suspension. Go back and do your work while the process is over. Of course, when they finish and they submit the report to the Chief Justice, because the committee is set up by the Chief Justice, they will submit their report to the Chief Justice. When the Chief Justice gets the report, she's unable to do anything to it. She simply forwards it to the President. And the President has no discretion in the matter. What they have recommended, if they have recommended that we found the person guilty of the allegations made, and so the person should lose their office, the President cannot do, like they say in in our parlance, FOCO. All he has to do is simply write a letter to the person saying that you have been dismissed, removed from office. So the President has a role to play.
And if they say, look,
so it is good to start.
She should stay.
It is good to start using him as a postmaster or the conveyor belt, so to speak.
I see.
You know, quickly to just add to what he said, in Opon's case, now, you see, with the judicial, maybe some of our learning, when a decision is made and a counter decision or another school of thought makes a decision, it becomes a little bit difficult to know what is certain. You see, in the J2 case, they were saying that administrative, it could be administrative or quasi-judicial. That is what, it doesn't make it certain to know where exactly you want to go. Now, continuing with where he left it, I think that it was for a good reason that the President is brought in, that he serves also as check and balances. If you look at the procedure, Council of State is involved, Judicial Council is involved. I believe that also they've taken out people who are members of Parliament, people who are also lawyers, so that the composition would be people with the kind of integrity, devoid of the politics that will be in. And I believe that no person as a superior court judge or somebody will sit on that committee without a modicum of integrity. I believe they've been tried and tested. That is why sometimes they have removed their political inclination and others from that process.
But looking at how sensitive the position is, And we in Ghana, you know, I think apart from religion, the next thing we worship is voting. I think it's even on par now. You know, we vote as much as we worship. And here is the person who, you know, supersedes all these things. Now, we can take politics out of it as much as we can. But when she was coming into office, there was a lot of agitation from MPP. Were not comfortable. They were not comfortable. In passing judgment, can this come to play, or all this will be rubbished and you just pass your judgment? Or does it come to play that, listen, these people who are not comfortable with your coming into office, now you come to office, you know, the petition appears and, you know, you're going through the process. Does it you know, hold any water, Victor?
Yes, you see, there has been some perception in public that I think this has political undercurrents and the rest. And from turn of events, you come to believe that, yes, there is some underhand dealing or invisible hands in it. However, I always ask myself the question, yes, it may have influence on it, but will the people, the committee, or the Chief Justice do the bidding of the politician at the expense of the duty that has been imposed on them, that has been entrusted in their hands? Because it is believed that they would sit on that committee with some integrity, some credibility. So, yes, we believe that these are things that are going on. But would they do the bidding? I think it is no. Because at the end of the day, it is the judiciary, it is the credibility, it is the integrity. If we lose that, it becomes a very difficult thing. That's not to say that being naive that the politician cannot do anything. The politician would always can want to have his way. But it's the people who sit on the committee. Now, there's one interesting thing that...
Before you move on, I want to find out how it works. I mean, they put 27 charges. Chief Justice goes through and think, look, 21 of these charges, I don't think, you know, will hold any water. But 6, I think she should come and answer. I mean, at that point, you know, would you say what they were nitpicking? Or, I mean, how do you politicize that if they throw all the cases away and find, look, there's this 6, I think you need to come in and answer?
Yeah, that's why it's a mandate that has been imposed on the Chief Justice that you cannot delegate. You would have to look at the petition, the content of the petition. Now you look at it and says that, yes, on the face of the petition, I think the issues that has been raised, you must answer them. That's the prima facie case. Mm-hmm. So that is the duty imposed on the Chief Justice. It is believed and must be that the Chief Justice could look at the petition with prying eyes and know that I think there are issues that have to be. That is the work that has been imposed on the Chief Justice. But you see, the scenario surrounding this particular case makes it even more confusing or more complex, in the sense that whilst this petition has been sent to the Chief Justice for her to determine the prima facie case, a case has been filed in court that, looking at Article 45 and 146, the case is Ayamga Yakubu versus Aklowo. I believe something is well. And this case is pending, that the Chief Justice should be restrained, that until they determine this matter, that the President says he believes that 45 is saying that the EC chairperson and others are only subjected to the Constitution. So it is a constitutional matter, and that is what the full panel of the Supreme Court should determine this matter. That's one of the things that has been filed.
Not a commission set up.
Not a commission, and he believes that the 146 is not. Now, for me, whilst this matter is pending, he has never, I don't think, any injunction or anything other restraining the Chief Justice to go on with the process. However, we have seen it where the Supreme Court, even when injunction and the rest has not been filed and cases are going on, they give an oral order and they don't go on, don't go ahead. We've seen it in the Abu Ramadan case. We've seen it in the case that was done by Afenyo Markins when the Electoral Commission was about to do the district level election and say, this matter is before us to determine. And you are still running adverts and going on. I thought that this matter coming before could have been looked at, even though if there is no merit, the Supreme Court itself, because it raises a lot of issues. It could have been looked before the case continued, or the committee, because it says that the reliefs the person is asking that the Chief Justice should be restrained. The Supreme Court itself should look at Article 45, 146, and look at the whole procedure, whether Electoral Commission would have to, or the chairperson would have to go through that process. Because they are looking at, yes, if the qualification for Electoral Commission is that you should be somebody who would have the same terms of condition like a Court of Appeal judge and the rest, that automatically make you a Superior Court judge. That is one of the questions that he wants the Constitution to be interpreted to look at it. That's one of the things that I felt that it's raising a lot of issues. Now,
before you go, let me bring something. We want to find out how the Chief Justice alone in her room or his room would decide that, okay, out of this 27, I think 6 is credible. I mean, in your case, how many charges did you take and how many did the Chief Justice think was credible to look at?
Right.
Did you see the petition?
The process, yeah, we saw it was running out. It was
in public. If that is it, yeah.
Nana, it's not mysticism. In fact, in our case, the Chief Justice did the prima facie determination and wrote to us to inform us that she has done that, and then added to that a 24-page document detailing how she went about the process. Yes, I looked at that, I looked at this, I looked at that. This has merit, this has no merit. This is frivolous, thrown out. You get it?
Now,
the Chief Justice
is trained to start with as a lawyer.
Yeah.
And may have been a judge and risen through the ranks.
You should credit the Chief Justice
with the ability to look at a document
and tell on the face of it that
this one, like we say in Akan, Bosrimka,
a meaning as well. Throw it out.
Yeah.
But you see, even that, they have developed a practice. When you bring it, the law says they should make a prima facie determination.
And I have explained that prima facie determination simply means there is something that is a bit weightier to look at, and that there is someone has to answer to something. It doesn't mean you have been judged. But when you come through the process, you can undo that first impression.
Yeah.
They are actually not required to look beyond the 4 corners of the document you have submitted to them. But in practice, this is what they have been doing. When the petition is submitted to them, they ask the respondent, the person who has been accused, to bring their response. When the response comes, they put it together with the petition. Now, I was referring to you about the case that I did for Richard Nyam. There was
I have some technical challenges, so let me just take a quick break and then we're coming. Sorry about that. Well, thank you very much for staying, and sorry for that brief interruption. But let me go to Samson. Samson, this time I want to find out. Look, I know
I needed to complete that point.
Okay, complete that for me.
That even though they are not under any obligation to ask the respondents or the person accused to bring their response, they have been doing it.
Yeah.
Because they want to have the other side to be able to see whether there is substance in what is being, spoken about. And I was saying that you would find that, for example, in the Richard Nyama case, there were several petitions that had been taken to the president and were forwarded to the Chief Justice. I was very clear from the start that to meet the threshold for a prima facie determination to be made, you didn't just need to sit down and write allegations on a piece of paper and go and give it to the president. That's what some people did. So they threw them, they trashed them, put them in the trash can. I said, if you want me to lead you in this matter, I need you to do a number of things. You have made allegation A, allegation B, allegation C. Bring me the proof. So he took his time. At a point, he felt I was frustrating him. And I said, well, you can look for another lawyer because I won't lead you without the basis. So he went and brought the documents, including audio documentation. We put all of them together and took it to them. So in fact, we took some audio, the president forwarded it to the CJ. We hadn't transcribed it. The CJ's office transcribed the audio and actually brought us a transcribed copy, a transcript. So you see, it is something that's not difficult to do. And it is not because the CJ looks through it and said there were 25 or so allegations. I find that only 6 of them should be looked into. No. You and I saw some of the allegations that were being made. Some of them were petty, to say the least. Somebody doesn't talk to the other colleague. That is an allegation. That is a ground on which you want to remove somebody from office. They don't talk to somebody. I mean, that was petty. So all of those, useless parts, clearly, we know that way, and then left the others that they think are substantial. If you hear what we are told prima facie has been made on, they are matters of procurement and allegations of compromise in the procurement system. So that is how that is done. Now, about what is pending before the Supreme Court, we definitely cannot comment on that. But you see, when that gentleman goes to the Supreme Court and says, I think the EC boss should not be subjected to the same process that Shraj boss will be subjected to, NCC boss should be subjected to. Some of us had made our opinions known earlier when the subject came for discussion. And our earlier opinions were that, I mean, it's a moot argument we want to make. Okay, so the Constitution says you enjoy the terms and conditions of a Justice of the Court of Appeal. And you say the terms of conditions of service of the Justice of the Court of Appeal should not include you going through what a Justice of the Court of Appeal will go through when they are found to have misconducted themselves. I mean, that's difficult to say. So let's allow the process to go through, and let's see in the end what it will produce. But again, if the Chief Justice has made a prima facie and says only 6 of the many are the issues to determine, then it tells us that a serious thing has been done and that a serious committee will go through the whole processes. Of course, we are aware of letters that are being written and claims that are being made of things that ought to be done that are not being done. I'm sure we'll get there. When we get there, we can deal with those others.
Do you think, Charlotte will be asked to step aside?
The suspension is not automatic. Okay. There are people who think that for as long as a prima facie has been made, you ought to be suspended. No. The Article 14610 says that if the Judicial Council advises the President that he should suspend, then he will suspend. And even if when the President suspends, the law says at any time he can revoke the suspension. It's not automatic.
Even if it will hinder the investigation?
It's not automatic. You see, when we were pursuing Shraj matter, it was part of our strategy. You don't know what the strategy of the lawyers, of the petitioners is in this matter. It was part of our strategy. And it was not just a mere strategy. because we felt that we needed a certain access to the charge to firm up our evidence. We needed persons who are in there to come and testify when the process, starts. We felt that if she's still there, she will not allow that, all the people will be afraid. They'll be intimidated. You get it? So we wrote. We didn't wait for the process to start. Immediately prima facie was made, we wrote and said, please, let her go and rest whilst the process goes on. And it worked. So it's not automatic. It is possible that they can continue to carry on their job whilst the probe is going on. In Strat, for example, the Chief Justice said it ought to be done fast. So they set aside 3 days, every week, 3 days, for us to meet. And it took almost a year to finish. These are 3 commissioners involved. I don't know how long it is going to take, because you cannot even guarantee that the process will commence in January as we understand. Because by January, there may be one suit or the other. For example, the Osei has written a letter.
Yeah.
And the letter has been leaked. In the letter, she says that as we speak, she has not been furnished with a copy of the petition. That clearly is wrong. She ought to have been given a copy of the petition. Well, she may be furnished because she wrote to the Chief Justice and saying, I want a copy. She wrote to the President and saying, I want a copy. She may be furnished. If she is furnished, that matter closes. But she says, apart from not being furnished a copy, I have not been told who are the members of the committee. She ought to be told. Because if she has objections to some of the members, if some of the members of the committee have relations, who are connected to some of the contracts, or they themselves have had something to do with the contract, she and her lawyers ought to be able to object to that person being there. If they have a certain interest that will clearly suggest a bias, they ought to be able to object to that person being part of it. And if they have not been told who are the members, that is not good enough. In fact, it should be documented. It is, we understand it is only when they appeared yesterday that they were told that Justice Benning will be the chairperson, or he's a chairperson, and that the 2 other justices of the Court of Appeal, and then 1 other person who is not a judge, who is not an MP, and who is not a member of the Council of State. And then there's a lady. That lady's identity has not been disclosed to them. We understand there's claim of some security reasons. No. It is at the appearance that we are now being told that there were 2 petitioners, drivers of the Electoral Commission. When initially we understood that the petition had been submitted by over a dozen people. So she says, furnish me a copy. She might want to investigate, because you ought to know your accusers.
Yeah.
She might want to know, is it the petition that was taken to the president that has come to this place? Because that petition had more than 2 people. And when we were asked to respond, we responded to a petition that has more than 2 petitioners. So we should get ready, because it may not going to be a smooth ride. And it may take even longer. But in that letter, there's one thing I disagree with her, where she says she ought to be furnished with the terms of reference of the committee. I think that is absolutely out of the way. It's wrong. The Constitution provides the terms of reference for the committee. It says the committee shall inquire. So they are doing an inquisition. They ought not tell you that, oh, we will do this, we don't have power to do that. No, that is not the way. So on that score, I think she's wrong. But on being furnished with a copy of the petition, on being furnished with the membership, and even the prima facie determination, the president, as I have spoken to, those things ought to be available.
Is this a new test of the judicial system?
No, I believe that this is a new test. As he's saying that there is a member whose identity has not been. I believe that the previous one where we saw Justice Derry and others, and we saw maybe the Anas going with his face covered, that your accuser You can't look at him. People felt strongly that it was wrong. It was a wrong thing that has been done in our jurisprudence. And if the same thing is happening now, I think it's an opportunity for it to be looked at. That if somebody accuses me, I can't look into the person's face. I won't know the person.
No, but in that case, he was named. It is only his face they
he was
didn't look
named.
at.
Yes,
he was
but
named.
yeah, he was named.
But here you are, the person has not been named.
No name, no face.
The person has not been named. It raises issues. It raises issues.
Could be a rival.
You know, so
ready to send you to the gallows.
It's an opportunity that we need to look at, and it is the same court that can right some of the things that they think they did not do well in this time. It presents an opportunity to them. But looking at it, I don't think, as Samson has said, it's going to be a child's play that, because it comes with rights, it comes with liabilities. And they would take their time to make sure they put up a forceful case, do a very good job, and it's going to be a long way, as I see it.
Lawyers of each party will cross-examine each of the petitioners and the respondent. It's not a joke.
And you see,
it's not a joke. I remember cross-examining Loretta Lamte. I remember cross-examining. I'll ask her questions that will infuriate her, and she'll say, but she's a lawyer of many years at the bar, and me, who am I? Yeah. And then she'll be told that over here, he's lawyer for the petitioner, so please respond to his questions.
And you know, looking at the caliber of people going before this committee, and looking at their works, what they do, it's not going to be an easy thing. I can tell you that it will take us some time. But you know, the wheel of justice grinds slowly, and justice hurried is justice buried. So let's brace ourselves for it. I believe that at the end of the day, everybody would see that a good job has been done. The frontiers of the law has been expanded.
But I just hope that the two political divide will take the politics out and educate us.
I think you concentrate on the politics too much. We know these ugly noises by the two parties. These people who sit there will ignore these ugly noises.
No,
when
but
she was being
the
appointed,
general public.
You mentioned when she was being appointed, then people were saying blah, blah, blah. Now there is a petition. People are saying it is MPP that is behind it. When shall we have an end to this sector?
The reason why you cannot wish away the political aspect of it is that
it's real.
It's real. And who comes to sit if they decide that she should be impeached or all the commissioners to go? The people coming to sit in. If another party comes into power, you've been appointed by another party, you know, it is not going to
all too soon time is up. I bet you something, not many programs will have this legal education like this. It will be a banter, he said, she said. But today, luckily, we have all been educated, so you know how technical it is. And it's not going to be a child's play, but I hope by the end of the day, we would have all been educated. I want to say big thank you to Samson, and big thank you to Victor for, you know, giving us this education on what's going to happen and what has happened. Stay tuned. This is just the beginning. There's more to come. Thank you for watching.